Welcome back. Of course, this is the moment we've been waiting for. We told you we have a very special guest today. We're talking to the Law Society of Kenya Chairman Eric Mutua. Of course, he has been here. We were talking about the constitutional perspective of the whole process that was before the Supreme Court ruling. Right now, we want to look at now how the whole process went forth. But of course, you remember his name was actually mentioned during the hearing, and well, Chief Justice Dr. Willie Mutunga gave a statement there saying that there was a report on the Daily Nation, page 5 specifically, that noted that Eric Mutua spoke, gave statements that were deemed to be prejudicial statements that actually ended up undermining the authority of the Supreme Court. We have a clip of that so that you get just a reminder of how that case went ahead. Let's take a look.
Whatever criticism anyone may have against the eventual court's ruling must wait until the conclusion of this case. We hereby issue summons for Mr. Eric Mutua to appear at the Supreme Court on a date and a time to be notified to him by the Registrar of the Supreme Court.
All right, so Eric Mutua is here, and we just want to get your perspective, because very quickly after that you said...
First of all, tell us what you said. What is it that he was complaining about, or the Supreme Court was complaining about? What is it?
Let me say what I think made the Supreme Court make the statement that I should be summoned to appear before the Supreme Court. Depending on what I heard, it must have been in relation to some report in the Nation newspaper, page 5, and in page 5 there were two reports.
Two stories.
Two stories.
Quoting you.
Quoting me. There was one about the audit team, the Law Society audit team, which we had unveiled. And there was another one, a small caption, which quoted me as having said that the ruling in respect of the further affidavit by the petitioners, which ruling struck out that further affidavit, is not a good precedent for the practice of law in the country. That is basically the caption. That is what that caption said. And then there was this other one, the audit. That is basically what I think informed the Supreme Court in making that determination or that decision.
Have you now been summoned?
Not yet. I've not received the summons from the Supreme Court yet. But as I said, once I receive the summons, I'll be able to attend the Supreme Court and I explain what I said.
Was it what you said was the fact that the Supreme Court did not allow that 900-page?
Yes, that is affidavit.
The one that was filed in the morning.
That is correct.
Many of the defense was completely against it, because they were saying there is no way they could respond to it in time. They just got it, and they couldn't go through all the 122 places that were being mentioned there. It was further evidence. That is what you said was wrong.
That is what I said, that the basis upon which the Supreme Court rejected that further evidence or that further affidavit based on the question of timelines and based on the question of the fact that it was filed without leave, out of time and without leave. That I said, in our daily practice as lawyers, we have gotten used to a situation where we are running away from technicalities, and that is the Constitution provides that, and the transformed judiciary has actually taken that position that we no longer practice law based on technicalities but on substantive justice. And that is what I say, that what will happen is that since a decision for the Supreme Court is constitutionally binding on all other courts and tribunals in the country, from the Court of Appeal to the subordinate court to the tribunals, then it means lawyers will want to go back to the old practice where they would keep on raising these technical issues and citing that decision by the Supreme Court. And I said, and in my opinion, that has nothing to do with discussing the merits of the court. I said it will impact negatively on how the practice of law is conducted in this country from the time the new judiciary came into place.
But given the timelines that were there with the Supreme Court, and given the time that was available, what could they have done?
Well,
if you are the chief, if you are in the Supreme Court, what would you have done yourself?
Well, in my opinion, if you asked me, I would look at the evidence. I would look at it. I would not I would not turn a blind eye to the evidence. I'll still look at it.
But then you see the concern is here they have to act constitutionally. According to the Constitution, they had a particular timeline. For them to consider the evidence, as you're saying, would mean they act unconstitutionally, depending on the constitutional calendar that they had.
Well, in my opinion, and may be wrong, but I think in my opinion, given the fact that the court itself had also made its own decision, what they call sumoto, on its own motion. It had already asked for evidence without being asked by anybody, and that was ongoing. In my opinion, there was adequate time to look at that affidavit.
Subsequently, you wrote an article in the newspapers criticizing commenting on the whole ruling.
What I did is I did a piece or an article,
yes,
which I circulated to the membership, telling our members, look, we have this decision from the Supreme Court, we have this ruling from the Supreme Court, we need to manage the manner in which we are applying this decision in our practice of law. Because depending on how the legal fraternity, that is the bar, applies that decision, we may end up going back to the old practice where would be able to knock out documents from the court record, apply for documents to be struck out on technical grounds. And that is what I said for us as lawyers, and actually for the judiciary in general. That is not a good practice. That is the article. The article basically talked about what does the judiciary transformation framework talk about, and I said this is what the transformation framework does. It says that we want progressive jurisprudence for the Supreme Court. We want to run away from technicalities. We want people or the courts to address issues based on substantive justice and not on technicalities. Then I went and looked at what has been the trend from the Court of Appeal to the High Court to the Subordinate Court in respect of now the policy of the current judiciary, and also the provisions of the Constitution, Article 159. And I said this is what the courts have done from the time the new judiciary came into place, and it appears, and lawyers have been very happy with that. It appears now the mindset has shifted from the old position to the new position, and everybody is very happy moving that forward. And I said, look, lawyers, my members of the Law Society, please, as we wait for the entire judgment, do not take advantage of the fact that there's this decision from the Supreme Court and you keep on citing that decision when you're litigating in courts. That's basically what I said.
Of course, something else that really springs out of that issue is the place that we are being told to move on. Of course, the Supreme Court made its ruling and it's the court of last resort, but there's still people who have grievances. And if I may just note an article that was written by Muthoni Wanyeki in the East African, she basically says in relation to concerns surrounding Forms 34s and 36, and she says if the tree is poisoned, the fruit is also poisoned. So when you're telling us to move on, what do you really mean? So how do you handle a situation whereby we also have people who have grievances?
Well, I would expect, and this is my position, that let's start from once a ruling has been made, like the ruling which was delivered by the Supreme Court on the affidavit and the rulings on the notice to produce, all those interlocutory rulings. one is entitled what he thinks about them. But once the judgment itself now, the reasoning itself comes out, then what I expect from people who are aggrieved is to interrogate that judgment in detail, in depth, then criticize that judgment. That is the only way. I mean, once the Supreme Court makes a determination, it is a final authority in judiciary, and you cannot question that. But you can criticize for purposes of developing jurisprudence, for academic purposes, for future presidents by the Supreme Court. You can now, as Muthoni says, at that appropriate time, the only thing is to lay it bare in the public domain, and then the public now will be able to chew it. The public will be able now to look at it and criticize, say this should have been done this way, this should have been done this way, and that is the only way you can deal with a decision for the Supreme Court.
What do you say about your friend Mutua, who also has written articles and even in the internet, and said he cannot accept?
No, I
he
think,
cannot, and he will not accept Uhuru Kenyatta as president.
I think that is an extreme position. You cannot say that as a Kenyan you are not going to accept. That is democracy, and I think once Kenyans have decided to elect the president-elect, Honorable Uhuru Kenyatta, and once the Supreme Court has made a decision that indeed the elections were credible, were free and fair, and it has confirmed the position of IEBC, then I think all of us, we respect democracy, we must move. We have decided, look, this is our president, and whether you have your own reservations as a person, that is your own reservations, but you cannot say that I'm not going to accept him as my president. No, he's our president, but that's democracy.
But Makawa Mutua is a professor of law at a very famous university in America. And he has been involved in the constitution making this country. It
is unfortunate that he made that kind of a statement. You cannot say that that is not my president. As a Kenyan, whether you elected the president or not, that's our president, as it is now. I also saw the article in the newspaper on Sunday where he calls the decision a legal opinion. That is not a legal opinion.
The decision of
it is a decision of the Supreme Court which is binding on every Kenyan. And I think it is in bad taste, in my opinion, to call it a legal opinion.
Because he was basically comparing a legal opinion and material reality.
Yes, I understand. He must have some bitterness because of the positions he's taken all along, and probably for good reason. But once we have a decision of that nature, you cannot trivialize it and say it's an opinion. It's not an opinion. It's a decision which is binding. A legal opinion means you could have another opinion which differs, another legal opinion which differs. But now we cannot have another judgment which differs with that, any other place, any other way in the world. So it's a decision, and that is for me, and I keep on saying, you respect the court, you respect the judiciary, but does that not mean that when it is appropriate, you cannot criticize it?
Talking about just reforms as far as the judiciary is concerned, there was an article written by Sam Omwenga on the Star, in the Star newspaper, and he wrote an open letter to the CJ saying, basically saying how the court decision on the main petition will be a test on whether the court has reformed. Would you say, looking at the whole hearing process plus the ruling, would you say that was a true test, that there has been reform as far as the judiciary is concerned?
Well, if you're asking me to answer the question based on the rulings, not the reasoning on the judgment itself, then I could respond and say that to some extent, and I've taken issue with this, to some extent, the question of the striking of that affidavit, the further affidavit, on the basis of time, does not reflect very well on the question of reforms in the judiciary.
All right. But what do you say of the opposition by the defense, who are saying, first of the argument that it was brought without authority?
Without leave, without permission,
leave,
yes,
without permission, that it was brought late, therefore they could not themselves have the time to go through it.
No.
Themselves, not the Supreme Court, the defense, because they were supposed to respond to it.
They have, of course, they have a point by saying that, look, this is an ambush because we don't have time to look at this. However, given the way the court managed its time, and given the fact that there was not going to be a reasoned judgment, that there will be only a brief judgment on the facts or the issues and the responses, I think if you want to look at the merits of a petition which was brought to court, time ought to have been found, in my opinion, to look at, to give even the other side an opportunity, even if it's 12 hours to respond. You can say 12 hours, look at this and respond. My biggest issue is that the kind of precedent which is set, the Supreme Court may have meant well, but the problem is now, in terms of what we call stare decisis, in terms of what we say as precedent, it is a constitutional requirement that once that decision has been rendered by the Supreme Court, no other court can deviate. It cannot go against that decision. And you can understand my concern is that once that decision is out there, once every lawyer has that decision, then once the lawyer cites that decision before another court, that is all. The court it has no discretion to either decline or admit the document. It is only one way route, say you have to decline the document because it's a constitutional requirement now.
Now let's move away from the High Court, from the Supreme Court to other issues.
Yes.
We know that now we have a parliament, we have a Senate, and there is a move to kill the Salaries and the Remuneration Commission.
Yes.
Reason, because we have lowered the salaries of our learned, our honorable governors. They are now called Your Excellency, the governors. Yes. The Excellencies, the governors, and honorable members and honorable senators. What do you say to that?
No, I think it's quite unfortunate. It's actually very sad, if you ask me, for either the National Assembly or the Senate or the governors or even a member of county assemblies to start engaging the Salaries and Remuneration Commission with a view to challenging its mandate or with a view to threatening it, to disband it or to discipline that commission. Because this is a commission which was set up after a lot of negotiations by Kenyans as to why is it that Parliament seems to be supreme in terms of determining its own salaries. That is basically what informed this commission, coupled with the fact that there was a lot of imbalances in terms of who earns what from the government, from the taxpayers' money. And this commission, when it came in, by the time it sits down and gives you some salary as a member of parliament, then it is informed by the totality of the Kenyan income in terms of the taxes which is collected and the budget. It looks and says, okay, from what we have, this is what you need to be paid. And I think there's no other institution which should want to get into the mandate of that commission in terms of determining salaries. And if parliamentarians want to engage that commission, then the best thing, as I've said before, is to prepare a memo, engage them and say, look, based on 1, 2, 3, we think that what you have given us is not adequate, and we are urging, we are appealing that you review your decision. That's the only thing they can do. But to threaten it, that is bad. One, because they don't have the mandate even to disband it. No, they don't. As I said before, if you want to do it, an entity or another person must find some misconduct on the part of any commissioner or all the commissioners and petition Parliament, tell Parliament, we are petitioning you to take action as against the Commission because of these reasons. Then a committee will be formed and it will look at those grievances. Then if there are reasonable grounds, then they will advise the President to constitute a tribunal for purposes of now making a decision as to whether they need to be disciplined or not. Yes.
Just looking at the issue of disbanding and forcing the Commission to hike their perks, of course you've said they have no power to disband the Salaries and Remuneration Commission. What about frustrating budget allocations so that they have the power sort of to bulldoze the Commission to work in their favor?
If they did that, is basically it's not going to affect the Commission. What is going to happen is that it will affect other institutions of government, but the Commission will be intact. What the Commission deals with is basically just remuneration. And if you are frustrating the budgetary allocation to other institutions, the Commission has already done its job. It said, for instance, Mutegi will be paid 5,000 shillings. Wherever the money is gotten, whatever Parliament does, it doesn't affect them. They have already made their decision. And even if you frustrate that, you don't change that decision. Yeah. The decision still remains.
We have a new act that was passed just before the 10th Parliament was dissolved, the National Government Coordination Act.
Yes.
Which sets up establishes the presence of county commissioners.
Yes.
And I think regional commissioners in the
county and sub-county commissioners. Yes.
And which is creating a kind of what the governors are calling a parallel system of government. Already some of them are complaining that they are being invited to go to the tomorrow swearing in through a chief. Because obviously these things are being done, the invitations are being done about the Office of the
President. Yes.
The representative of the Office of the President in the county is the county commissioner. The county commissioner representative in the village is the chief.
Yes.
So they feel demeaned.
No, I don't think that the National Government Coordination Act was well thought out. It may have been a good idea to try to place the provincial administration in a certain structure. But the way it was done under that act was not well thought out, in my opinion. Because what has happened is, if you look at the structure in the county government, we have the county governor, we have a sub-county where there will be an administrator of the sub-county. Then we have the ward, where there is an administrator in the ward, which is called a ward administrator. Then the village unit. Now, what they have done in the Act, the National Government Coordination Act, is to establish a county commissioner at the county level. Then again, they have gone to the sub-county and established a deputy commissioner who is in charge of the sub-county. And then you go to the ward, there is an assistant commissioner who is in charge of the ward. And then there is an unit for the village. So in essence, in every structure from the county, you have the governor, then you have the county commissioner, parallel. You go back to the county, sub-county. You have the sub-county administrator from the governor's side, and then you have from the provincial administration, you have the deputy commissioner. You go to the ward, same thing is replicated. Definitely there is a parallel kind of power between the national government and the county government. And remember, what the Constitution provided in the transition is that within 5 years, I think it is section 17 or 19 of the 6th schedule, within 5 years, the government was supposed to align the provincial administration to the county. That is not aligning, in my opinion, because you have just basically created a parallel power structure, but you have not aligned it, because the county governor cannot give any directions to the county commissioner. The county commissioner is answerable to the national government directly. So when you create that kind of power structure, which is parallel to the county governor, there is meant to be friction. And remember, under the Constitution, the county government and national government is supposed to operate in harmony. So there's not going to be any harmony. For me, that act of parliament is unconstitutional. Yes.
Just looking at the list of cabinet secretaries that is set to be unveiled perhaps from tomorrow, we have the National Assembly Committee on Appointments that is sent to vet the people in that list. How can we trust that the list will be based on meritocracy and not chronism, so to speak?
Well, you know, cabinets, basically cabinets, if you look at even the way the appointment of the cabinet, there's a lot of emphasis on the president to play a big role in the appointment, because he's the one who comes up with the names, he says these are the names of the cabinet secretaries, then the names would basically be approved by Parliament. I mean, if the Jubilee coalition has majority in Parliament, the names will definitely go through. So if you are talking about check and balances as to the persons who are being appointed to that position, it may not be there.
But there will be a parliamentary committee that will interview them, just like normal,
yes,
before the names are taken to Parliament.
Yes, but as I've said, if you have more people, I mean, more members of Parliament in Parliament, what is going to happen is, irrespective of what the committee says, once it goes to the floor, they will pass it. Yes.
Well, of course, tomorrow is a big day, and about 65 presidents of Africa have actually, in the African continent, have been invited.
Yes.
Plus Sudan's president. 54 rather.
Yes.
54. And we have Sudan's president, Omar al-Bashir, who has also been invited. And of course, we have all the ICC. Well, according to reports, he's expected to come in. Will that prove to be a challenge in terms of our relationship with the international community?
I know there's a judgment. I don't think it has been set aside. There's a judgment from the courts to the effect that
when he comes,
he should be arrested. The question is, has that order or judgment or decree, has it been passed over formally to the new Inspector General of Police? That is the only way you can now start raising issues as to whether...
Who should do that? The Registrar of the High Court?
No, it is the parties who went to court. I believe ICJ is part of the parties who went to court. So ICJ, that is the issues which probably one would want to look at. Has he been formally served with that decision of the court?
What you are suggesting, that ICJ today should go to the...
Yes, to serve
the Inspector General of Police.
Yes, with that decision or that decree, then that is the only way you can say you failed to execute a decision of the court, and then you can now have consequences. But as it is now, we said as a country, Kenya set a precedent by not arresting him. So again,
well, but after that, the judge ruled that when he comes, he shouldn't be arrested.
I believe, was that after or before? It was before. It was before. It was before he came. The judgment, if I'm not wrong, it must have been before he came. But notwithstanding, to just go back to your question, in terms of international relations, it will not sit in very well for the government to allow him to walk freely in the country, especially given the fact that we also have issues with the ICC at the moment. That is the current government with the ICC. Yes.
Just looking at the ICC case, of course, having witnesses at the very last minute saying, you know what, we're not ready to testify before the court.
Yes.
It has brought us a perception that, you know what, there's really no case at all. But Fatou Bensouda has come out clearly saying that this is purely media sensationalism. Are there any possible grounds that there is really a case from your perspective?
Well, from what I'm reading from the newspapers, if there were 12 witnesses, four of them have declined to testify. That remains with 8 witnesses. What it depends is you need to look at what these other 8 witnesses have to say. And if these 4 witnesses really, their evidence is weighty, or that is the prosecutor was to rely on any of those 4 witnesses to a very big extent to prove his case, then you can say that really the case may not be as strong as it was before. Yeah.
I don't understand this matter. Maybe you should explain to us, Kenyans, lay people. Why is it that witnesses have given statements, they have recanted, nothing happens to them, they have wasted their time, they have made people suffer. Like
5 years now.
You know,
and nothing happens to them. And maybe they were even given allowances or paid or whatever. Maybe they receive some benefit out of the statement route. How come they are getting scot-free?
There needs to be a thorough, use the word audit again, there needs to be a thorough audit of what is going on. Because on one side, if you look at their statements when they have recanted the earlier version of a statement, they say that they were forced into making certain allegations. That's one of the aspects. The other aspect is look at were they compromised in terms of whether being harassed or being threatened or being paid. And we look at these institutions which were probably used to gather the evidence. Did they compromise the rule of law? Did they actually coach these witnesses? All those are the things which, in my opinion, need to be looked at. And also, as you've said, there's an option which the prosecutor can take. He can actually take action against these witnesses. She can actually force them to testify. But the problem is, once you have a witness who is reluctant to testify, you can't put them on the dock if you're good enough in what you do, because what they would say would compromise your entire case. So you'd rather leave them alone without trying to follow up with those witnesses, because they may mess up your case further than how it's messed up by the recanting.
The Nigerian judge in the ICC was very annoyed with Bensouda that when the witnesses withdraw, he withdrew Muthaura's case instead of punishing witnesses. And he was saying, how can you do this? Which means if he withdrew Muthaura's case because of that, then he should also withdraw Uhuru's case. Or she should withdraw.
Well, this is my personal view. It doesn't reflect probably what many people, many lawyers would say. But I think part of the reason why she did not withdraw the case against Honorable Uhuru Kenyatta, the president-elect, is because she did not want to she did not want to be looked at like she was under pressure from certain quarters, or she was under pressure because of the changed circumstances to withdraw the case. That is basically my view. And if you look at what witness number 4 had to say in respect of Muthaura and in respect of Uhuru, then to a very large extent, the case against Uhuru is a very weak one. Yes.
All right. Perhaps a final word in relation to the fact that we are moving forward as a country, and the ICC sort of ghost is still hanging around us, with victims who have been waiting for 5 years and they're still waiting for justice. What is your final word?
Well, as a country, we'll wait for tomorrow's inauguration. We would celebrate as a country, and I think what will make or break this country, or the institution of the presidency and the government of the Honorable Uhuru Kenyatta, is how they manage the ICC issue. And I hope and pray that they would be able to manage it together with the ICC, not just Kenya, even the ICC itself, how they manage the ICC question because of the international reputation. Will really contribute a lot to whether we are going to take off or not. Yes.
Britain, the British High Commissioner said he cannot shake the hands of President Uhuru unless, I don't know. What do you see Britain
No,
do?
he has to respect the Kenyan's position, because once we have made a decision, once an election has occurred, it is not Uhuru you are shaking his hands. You are shaking the hands of Kenyans, the President of the Republic of Kenya. And I think he has no choice other to shake that hand. So you think
Britain will send a representative for the celebrations?
Definitely they are going to send. Britain will send a representative in the inauguration.
Or the High Commissioner himself?
Yes, or he himself, yes.
All right. Many thanks indeed. Talking to the Law Society of Kenya Chairman Eric Mutua. We'll be right back.